Senzo Meyiwa murder trial continuing in Pretoria today. It's been fascinating to follow. Our data analyst, Lambertus Steyn, has linked singer Kelly Khumalo to one of the accused on that night. Steyn also says none of the people in the house called the police or even an ambulance after Meyiwa was shot. That cross-examination is going to continue today. Well, let's unpack what has been happening in court, and if you would be so kind, Zola Majavu, senior legal practitioner. Zola, good morning to you. We can get your thoughts on what you're expecting later today. But first of all, how damning to your mind legally, as an expert in this, has this cell phone testimony been? How damaging to your mind?
Good morning, Brother Gareth, and good morning to our wonderful viewers. Firstly, I did say last week that which many people think that it was earth-shattering as far as Kelly Steyn's testimony is concerned may turn out to be a damn squib. Towards the latter part of the day yesterday, as Advocate Mshololo continued with a cross-examination, I think that point of view was vindicated. At the very least, or at the very most, all what Kelly Steyn has been able to put forth was that a gadget supposedly belonging to accused number 5 made contact with a gadget supposedly belonging to Miss Kelly Khumalo. That's the high watermark of his testimony. He was constrained to consider under cross-examination that that very gadget that is supposed to be belonging to accused number 5 was not even recorded under his name, nor is there any correlation between that gadget and his personal details. Now, that's a telling concession. The second most concession was that not only was he unable to confirm whether or not the two persons to whom he referred were actually the ones that used those gadgets, he also considered, and correctly so in my view, that he is none the wiser because he is not armed with the benefit of the actual conversation as to who said what, which may point out circumstantially towards some form of conspiracy to commit a crime, let alone the crime with which these accused are charged. And most importantly, Ms. Kelly Khumalo is on record on the admission of the state, not even a suspect. So I do not believe that it is of any moment. All accused number 5 has to do, if he is put to the stand, he is simply going to deny that he was using the gadget at that particular point in time, and he owes no one an explanation to explain anything beyond that, because the onus is not on him to prove anything. If there is if there is, for example, a version that links him, he simply has to rebut it, and the rebuttal can be, I did not use it, that's not even my gadget, because admittedly, it's not even recorded. Unless there is someone who is going to come and corroborate, externally and independently to say, on that particular day, I saw accused number 5 using this particular gadget whose EMEI is correlating to what Kelly Steyn is talking about. So at the very least, barring any corroborative external evidence by another party, I think Kelly Steyn's testimony is not taking the matter any further.
I want to ask as well, because you're quite right. I think when what was being called those bombshells being dropped late last week, Zola, when you and I spoke, I think it's because we hadn't had, and this is all coming from those of us who are not trained legal practitioners or lawyers or advocates. It sounds very explosive, but really when the defense then climbs in, you realize there actually might not be that much there. I am curious, though, and tell me how much weight you think this has when it comes to the events of that night, that no one, it seems, according to Colonel Steyn, phoned the police or phoned an ambulance after the shooting, according to Colonel Steyn. How much weight does that bear in a case like this?
It would be a factor that cannot be ignored, because you weave together a circumstantial plot. So that may be one of the factors that says logic and human nature dictates that in the event of a trauma such as that particular one, the first port of call would be to call for help, either in the form of the police or in the form of some medical attention. If none of those who were in the house did not do that, it is curious, it is suspicious, but that in and of itself does not seem to indicate that they were part of a conspiracy or they may have been part of a criminal enterprise. It may be a theory that can still be developed by further corroborative evidence, but I would not be too worried if I was the defense on behalf of those parties, but it does call for some explanation.
It certainly does. And the only reason I'm asking, Zola, the following question, and maybe to someone of your standing, it seems quite obvious, but I'm only asking because a few people were asking me about it yesterday, and I knew I was going to talk about you. The name Kelly Khumalo, of course, coming up repeatedly. There was no intention for Kelly Khumalo to be called to this court case. Does that mean there's no chance of it ever happening, or could she still be called to come forward and give testimony? Is that option still open to either defense or prosecution?
It's a fair question, and one can understand why you would be asked about that. Remember, as we speak now, the defense has a list of all the witnesses. The defense has statements of all the witnesses and any other document which may be referred to during this trial, to the extent that the prosecution may wish to rely on that evidential material to discharge the onus of proof that rests on it. However, it is open to the prosecution to decide who amongst that list they may still persist in calling. They are not obliged to call of them. They are not obliged to call them in the order in which they are listed. So in the event the prosecution, for reasons that they are perfectly entitled to, decide not to call Ms. Kelly Khumalo, and Ms. Kelly Khumalo was on the list of witnesses, it then means that it is open to any of the defense counsel to then call Ms. Kelly Khumalo, whose statement they already have. They know what she's going to say. There's no element of surprise. They may want to call her to put her into the witness box to the extent that they believe that such exercise may go some distance in vindicating their clients, and obviously hoping that if she is in the box, she may contradict her written statement that they are already in possession of, and to the extent that such contradictions may be material and may point to some vindication on the part of that client. So you don't just call a witness for the sake of calling a witness. There must be value, there must be utility to be derived from your point of view in calling that witness. If, for example, Kelly Khumalo's testimony, which the defense counsel has in the form of a statement, is not going to assist their case, it would then be foolhardy to call them just because her name kept on being repeatedly mentioned. It's part of a theory. If it does not harm my client, I just let her be. But if I do believe that there is some part of a testimony that may point towards exculpatorily in the direction of my client, then I will call her so that she can vindicate my client. Otherwise, you stay away. The same goes for cross-examination. If a witness has not implicated your client, there's no point in cross-examining because you're simply flogging a dead horse. Why go stir up a hornet's nest when this witness, in fact, Colonel Steyn, in his credit, he actually said, "Ma'am, I am unable to even confirm what was said in between the conversation. All I am able to tell you is that Gadget A was used to contact Gadget B. But I am also unable to say the owner of Gadget A was in fact the person who used Gadget A at the time." And he kept on saying, the investigation team will come and confirm, which means it's actually a clear concession that based on his own examination, on account of his own expertise, that turns out not to be such an expertise after all, because he only had a crash course of 6 weeks. He considered that he is unable to say accused number 5 is the one who used this gadget. And he himself dropped a bombshell. He actually said it was not even Richard in his name. So the question is, on what heavenly basis are you then even linking it to accused number 5? He can only do so because someone told him that it must be belonging to accused number 5. But beyond that, he could not give the court any conclusive evidence on pain of his conscience. And that's why he correctly conceded. So I do not think there is anything so far that positively links accused number 5 with the use of that gadget in any manner that points to a conspiracy. It is juicy It is of public
and
interest.
I think that's
rather.
exactly it. And this is
Interesting
why
to the
I've
public.
always hoped to get you on, because for those of us who aren't trained legally, it looks very interesting and very contestational on television, but actually it's quite normal. And that's why we have you to make sense of it for us. Zola, thank you very, very much indeed for your time. Hopefully we'll